This episode of AHLA Speaking of Health Law is brought to you by AHLA members and donors like you. For more information, visit AmericanHealthLaw.org.
Hi, and welcome to everyone out in AHLA podcast land. Today we're going to be exploring how healthcare organizations handle enforcement when it lands on their doorstep. My name is Miriam Swedlow. I am an associate in the healthcare practice group at Wright Tremaine. A large part of my practice involves advocating on behalf of hospitals, health systems, healthcare entities, and providers who are facing actual or threatened government enforcement actions. Joining me today is Ryan Belton and Kris Deyerle. The three of us had the pleasure of presenting on this topic at the recent AHLA In-House Program that happened on June 29th in beautiful, lovely San Diego. Before we delve into our conversation about that presentation and points of that presentation, Kris, Ryan, why don't you share a little bit with the audience some of your background?
I would be happy to. My name is Kris Deyerle. I'm the General Counsel of Confluence Health, a rural integrated health care delivery system in North Central Washington. Ryan?
Yeah, thanks, Kris. I'm Ryan Belton. I'm Senior Counsel at PeaceHealth. It's a Catholic nonprofit health system. We're based in Vancouver, Washington, and have operations through Oregon, Washington, and Southeast Alaska. And to just succinctly describe my role here, I'll just say I'm Operations Counsel. I work closely with our compliance, regulatory, and risk departments, among others. So with that out of the way, like Miriam said, we're talking about government enforcement and some of the tools they used. In our June presentation, we focused on a handful of tools that regulators may employ. So think audits, subpoenas, civil investigative demands, search warrants, and some of the best practices for how we respond to those. And that's what we'll be focusing on today. So we'll jump right in, start with audits. Kris and Miriam, as you know, there are several types of audits, including RAC, MAC, CERT, UPIC, you have OIG audits, OCR audits. I thought it might be helpful for our audience to give a quick, just kind of high-level overview of some of the common audit types you've encountered. And Kris, maybe since you're in-house and oftentimes audits are handled in-house, can you tell us some about some of the audits you've dealt with and what distinguishes them one from another?
Certainly. I think over my tenure, I've received audits from almost every governmental agency that issues audits, starting with like CMS, the IRS audits, RAC audits, OIG audits, OCR audits. Generally, the audits I've received, for the most part, have been, thank goodness, routine, non-targeted reviews by agencies, particularly CMS or the IRS. Those audits have been primarily administrative in nature. We have received RAC audits as well, which are also fairly targeted, but smaller in scale, not the huge RAC audits that we've seen. Unfortunately, I have been the recipient of some OIG audits. They've been a little more targeted with more of a federal regulatory slant to them. And I have been the recipient of some OCR audits coming in to look at our practices with regards in particular to providing care to those who English is not their primary language. In today's regulatory environment, I find that being the recipient of these kinds of audits a little more stressful than I ever used to, because it's now that the government is extremely focused on fraud in healthcare, there is always the concern that one government agency will share the results of an audit or share what they receive in response to an audit with other governmental agencies.
Yeah, I think that's an excellent point, Kris, because we do know that there's, more and more collaboration on the government side. So what kind of feels like it could be pretty benign could suddenly escalate quicker behind the scenes, that you don't know. And with the, I think the fact that the government's really relying also so heavily on technology and like massive data sweeps and things like that. So yeah, it's an excellent point.
Yeah, thank you both. Miriam, what are maybe some best practices that apply across the board? We've talked about, Kris just mentioned a lot of different types of audits, but across the board, what are some best ways to approach them?
Yeah, I mean, I think you'll hear a lot of these same, we know like these are a lot of the same themes across all of these, right? You want to respond timely, you want to be professional when you're dealing with the government. So right away, let them know that you've received it, acknowledge receipt, and then take a look at it, really carefully review what you have. What agency has issued it? What are they asking for? Then you want to involve legal counsel, whether that's internal, which is likely going to be the case, right off the bat, and then your internal legal counsel can assess whether it makes sense to also collaborate with outside counsel, given potential risk that might arise from the audit itself. You want to make sure that you're documenting everything. Like you want to make sure that if somebody comes back and asks you what you did, you can coherently be able to tell them what happened and the steps that were taken. And from my perspective, I just think it's always very helpful and critical to just not be hesitant to engage with the government and have it be a conversation, and rather than just kind of reacting defensively.
Yeah, that's great. Thanks for that. So I thought we'd just run through one of the examples we used in our presentation as an illustration. So Kris, allow me to set the table for a second. Let's suppose that you're in-house counsel for a nonprofit hospital with 300 beds, and you receive notice of an OIG audit that's targeting some inpatient rehab claims for medical necessity, coding accuracy, physician certifications, discharge documentation. And the notice requests 40 random claims and gives you 30 days to respond. So with all that information, what's your first move as counsel?
So initially I look at the audit request and I see what its scope is and try to ascertain, is this a targeted request of us, or is this something that's a general request of this government agency that they're doing to more than one provider? If I feel it's a targeted request, I'm initially going to engage outside counsel to assist me with this audit. At the same time, I might be engaging outside counsel. I'm going to be working with my compliance team and potentially my risk management team to gather whatever documents are responsive to this request, so that we can begin reviewing them internally to see if there's going to be any kind of issue with the documents that we're turning over. Even if I haven't engaged outside counsel in the first blush, if I see anything that may be concerning in what I'm going asked to turn over, I'm going to engage outside counsel to help me frame whatever I'm sending out.
So as a follow-up to the first thing you said there, and trying to ascertain whether you're being targeted, what ways have been helpful for you to find out that information? Are you plugged into local hospital associations? Are you calling counsel? Are you calling, phone a friend at a different organization? What's your approach there?
From my perspective, I would probably reach out to the hospital association at the same time I'm reaching out to outside counsel. They generally, outside counsel, have their ears open and they're hearing more than I'm hearing in North Central Washington. So I rely on them to have the relationships with the government officials, folks working in the government sphere, connecting with their other counsel resources to know what's going on in the industry.
I would imagine the type of audit and the requests that are being asked for also might give you some sense. If it seems very, very, very targeted and specific to your organization or some events that have happened or whatnot, it's much more likely to be, okay, they're looking for something or concerned about something, as opposed to, there's been something published by the OIG of an area that they are looking, that they're recommending focus, and then 3 months later you get hit with an audit and you're like, okay, that's, this sounds pretty routine.
Yeah. So Miriam, as outside counsel, assume you get that call from Kris. What things are you focusing on?
Well, I mean, I would, you definitely want to know and understand kind of what they're asking for. My first kind of engagement would be, what is my in-house counsel concerned about? They have, they know kind of, much more information than I do. And if they have specific concerns, I need to be aware of those and kind of follow those down. Also, in-house counsel is going to be extremely helpful in helping to understand the stakeholders on the other side and who's going to be easier to get information from, and maybe where some roadblocks might arise in actually like gathering and responding to the audit requests, and really just collaborating to get a game plan. Do we need to ask for an extension? Do we, has there already been engagement with the government, or do we need to make that as quickly as possible? Things like that, kind of, just really like setting it up as, here's what we have. Let's create a game plan, and where do we go from there?
Okay. And I wanted to maybe just explore one of the wrinkles that we had thrown into our presentation hypothetical. And in the interest of time, we probably can't get to all of them, but one was, in responding to the audit, the team discovers that some of the records may not meet medical necessity. Maybe you can talk a little bit about, what to do in that kind of a situation to mitigate any potential exposure.
Yeah, I mean, I think that's always, the dread, right? You're compiling documents to turn over, and suddenly in your review before pulling them out, you recognize, oh my gosh, there's been some errors, or there's some bad facts here. And I mean, facts are what they are, and at least when, the helpful thing is, if there are bad facts, we want to know them before those facts are turned over to the government. And so knowing about them is extremely helpful. We'd much rather to have that sense. Plus, we can then decide what steps need to be taken. Do we start resolving? Do we start making internal changes? Is this a systemic thing, or was this just inadvertent errors? And then, of course, when you're turning over information to the government, you want to be able to have a narrative and an explanation. Hey, here's what we discovered, here's what's been done, here's why we don't think that it's a problem that the government needs to be concerned about, right? And so, the key is, if we can control that narrative as best as we can, that's going to be much more helpful than being on the back foot and just responding to kind of peppered questions from the government. Plus, you're offering up goodwill. You're showing the government we're not trying to hide anything here. We're wanting to work with the government. We want to make sure that there's no concerns.
Yeah, all really, really helpful advice. In interest of time, Miriam, maybe you can walk us through some of the additional fun tools that
right, like the what we want. We do not want an audit to lead to next.
Right. Yeah. So what comes next?
So one of the big areas that we talked about in our presentation, and of course, unfortunately, healthcare entities have to kind of contend with in dealing with government threatened actual investigation tools, are of course the subpoena or the civil investigative demand, or CID, which are very, very similar, but of course there are key differences between the two. Ryan, why don't you describe some examples of CIDs and subpoenas that are typically seen within the healthcare space?
Sure. So, the one that I think everybody dreads is, if you're under investigation for an alleged False Claims Act violation, then I think you can expect to see a CID issued by the Department of Justice. Also, state attorneys general offices may issue either a subpoena or a CID, just depending on what stage you may be in litigation. Courts as well can issue some civil subpoenas as part of litigation that you might be a party to. And then even if you're not a party, you may receive third-party subpoenas, maybe from a regulatory agency that perhaps they're investigating an entity that you've done business with, and they want to understand more about what transpired as part of those transactions. So those are a few.
Yeah, I mean, and especially I would imagine for hospitals that license professionals, then there's all the professional licensing bodies that when they're investigating an individual, then they might come to the employer or hospital to seeking records as part of through a third-party subpoena if necessary, things like that. So Kris, in your experience, what are best practices you have employed when responding to a subpoena or a CID?
So in general, when I receive a subpoena or a CID, which I hopefully will never receive from the DOJ, although can't count your chickens, I generally look at the subpoena and try to ascertain the scope and whether or not this, again, like your audits, is it targeted or just general? Am I the target of this subpoena, or am I a third party that the government's just seeking information from? So I look at the scope. Does it seem overly broad? Is it a narrowly focused subpoena? And then I'm trying to ascertain who within my organization do I have to reach out to get that information. So I'm thinking about who's going to be on my team to help pull together the information that's being requested. And then another thing I'm looking at is, are they requesting PHI? Because oftentimes then that requires another level of scrutiny, not only on my end, but engaging outside counsel to try to narrow the scope maybe, or ensure that this governmental request meets all the state and federal requirements under HIPAA for releasing medical records. So that's generally first steps from my end. In general, if I'm getting a subpoena for documents from a federal agency, I, of course, am reaching out to outside counsel to help me with that request, particularly if it's a broad request, because my hope is that they will be able to narrow it and streamline that request.
Yeah, and I'll just add one thing. I think Kris hit it on the head. Convening the right team, super important. Including, who may be the custodian of the records that are being requested, and making sure that we promptly get out some kind of a document preservation notice or memo or lit hold, so that we can keep those and respond.
Yeah, I find that the government subpoenas that I have received seem to, the government has a different idea of my document infrastructure. They seem to assume that we have an integrated document management system, so I can just put out a litigation hold request and, I can pull all the relevant information quickly. And although that may be true in my organization with regards to, say, emails or the text messages that are done through our team system, we don't have a document management system. So I need to identify individuals who I think may have responsive documents, reach out to them to see who they think may have responsive documents, and then kind of do a broad blast email explaining why I need you to preserve these documents. We were in receipt of a subpoena. This is what I need you to do, and then field all the questions that come back.
Right,
so.
Right. I think one of the things you commented on like the government has this like view of what an entity's capabilities are. And the other thing I think they forget is, they'll sometimes issue these requests and that it's just this massively long timeline. And they forget in the age of technology, like you have these cobbled together systems. You might have had like a whole new system. A hospital might have been affiliated or acquired. People come and go. And so it's not this like easy set kind of, search history. Everything's fine. It's like you've got like so many hurdles that then have to kind of be navigated through, but also then like communicated to the government and explained of like, mitigating expectation, managing expectations on their side. It's always a delicate balance. Ryan.
I think that's particularly true when the subpoenas are broad and they're asking for information and your IT team is throwing out word searches and you're getting back, oh, look, there are 10,000 emails that fit into this, and you can't possibly search through them all.
Yeah.
So.
Well, and then when there is that expectation of a broad ESI, kind of trying to like it's just such an extraordinary cost burden for organizations and trying to, really like show that to the government when they're, especially if it's, it just feels like an effort of futility sometimes. But I think that's one of the, it is a frustration in dealing with the government because in this type of space where it's very different than normal litigation, civil litigation, where discovery is kind of an equal playing field. Kind of there's this kind of exchange of information. In these types of scenarios, the posture is very different. The government knows what information it has, but as the responding entity, you don't know what they have. You don't know kind of what you have a sense of, but you don't really know what their concerns are, and they hold all the power. And so it's just it's psychologically just very and operationally extremely frustrating in my experience. So Ryan, you mentioned litigation holds, and Kris, you did as well. In our scenario that we kind of walked through during our presentation, our exemplar healthcare entity, Breachwell Health, did make some, let's say, missteps in issuing its litigation hold following the receipt of a subpoena from HHS ORC. Can you both kind of weigh in on, like just factors and things that you need to think through in approaching the organization with a litigation hold?
Sure. I think, as Kris mentioned earlier, just one of the biggest things is just identifying who the audience is and who is going to have responsive documents. We don't want to be over-inclusive in notifying, everybody in the organization that we have this investigation going on. I think also just trying to educate them a little bit on how it works and the need to preserve those. Folks can get a little bit excited when they get a notice like that, and you want to be able to try to curb water cooler talk and gossip and things like that. And so just helping them understand that, hey, this is part of business, but we also need to just kind of keep keep things confidential that need to be kept confidential and proceed that way.
Yeah, it's like this this tightrope of like, I need to give you enough information so that you can make sure that we're holding on to what we need to, but I don't want to give you so much information to freak you out and cause complete chaos in the organization.
Exactly.
So another thing that we talked about in our Breachwell scenario was that in that scenario, OCR, as part of subpoena, issued interview subpoenas with some of the employees. What are some considerations that you kind of have to keep in mind when you have the government wanting to speak to employees or other stakeholders during the course of an investigation?
So my general rule of thumb, if the government wants to interview my employees, to quickly loop in outside counsel, and be it outside counsel that is engaged to represent that individual employee specifically, and I, as the employer, are just kind of paying the bill, and they have that one-on-one relationship with the attorney, or something more general. But because employees, this is not what they do in their general course of business, is get interviewed by government officials. And they're very nervous. They want to do anything possible to avoid it. So engaging outside counsel to help walk them through the process, prep them for any interview, and be with them during the interview, I think is integral. It also gives me an ear to what's being said and what's being asked. So I find that very important. And since I'm not a litigator, I don't deal with government investigators on a regular basis, thank goodness, I need outside counsel to do that for me.
Yeah, Ryan, do you have any other?
Not really. I'll echo everything that Kris just said. Yeah.
I think it's like, it's so stressful to be interviewed, especially if it in a CID, or if there's some, you've got a court reporter, if it's very formalized and whatnot. And so it's helpful to have outside counsel, some counsel there with the employee to just be an advocate for them in the room. Like, even if it's unnecessary, my experience, the government is, they're all decent people, and they're not there to beat up on the employees, and behave pretty, respectfully. Just knowing that there's somebody there to advocate for you is very helpful. Of course, it's very beneficial for the organization to know what questions were asked, kind of what the tone was, kind of what did they focus on, and things like that.
I will jump in just to say, in my experience, it has been helpful to have the outside attorney, and I felt I've had maybe some value add in just being the trusted, I have the relationship with that client, and right. So just I'm able at least to reiterate some of what counsel is saying, and the advice I give is general, but it's generally, you don't want to be hostile to the regulator coming in. You also don't need to be super helpful and do their job for them. You don't need to offer them, more than what they're asking for.
Right.
Right. So sometimes that tag team approach.
I think my two golden rules are: be honest, right? Like, I think you can never underestimate the power of telling somebody, we want you to be honest, right? But also letting them know your only obligation is to answer the question asked. Yeah. So answer the question asked honestly, and that's kind of like the fundamental kind of thing. But yeah, definitely very helpful space to have outside counsel. And you definitely don't want to do like our dear client did in our example case study, and just have the employees interviewed without any engagement prior by internal or external counsel. So I think that's moving away from our, kind of controlled and, intense but controlled enforcement actions. At the last tool that we talked about was search warrants. So I'm going to turn that over to you, Kris.
Yeah, so search warrants can be a little more stressful than the subpoenas or CIDs that you receive, where you have time to actually formulate a response, versus a search warrant. The individuals show up in person and they want to do their searches at that time. So search warrants generally can be issued both by judicial or administrative agencies. They are supported by probable cause, but they are served during business hours usually, and in person. So, and there's typically no notice that you're going to be served with a search warrant. The only benefit to a search warrant, unlike a CID or a subpoena, is it is limited to in search to the person or place that's identified in the search warrant, the time of the search, and the items to be searched. So, Ryan, with all that background, as in-house counsel, what are your key practices when you're faced with a search warrant?
Yeah, preparation is really the name of the game. We've done a lot of work at PeaceHealth with frontline employees and leadership, just educating them on how to respond. We've got a bit of a playbook, and an important, critical part of that playbook is contacting legal as soon as possible. And we've gone so far as to set up actually a legal hotline in our organization that the legal department staffs 24/7.
I think that's awesome. You're not a clinician, so you don't have to be on call, but yet you're on call anyhow.
So, Miriam, for in-house counsel, what do you think should be our immediate actions upon receipt of a search warrant?
Well, certainly you want to look at that warrant. So you want to get the credentials of the enforcement agents that are there at the scene. So, you want to make sure you're professional. You don't want to be obstructionist, but you also want to verify, let me see your credentials so that I know that you are authorized to be here. Let me look at the search warrant. I want to see the issuing order that is giving the authority for you to be here unannounced. And then, of course, because they're technically limited to the scope of what is in that search warrant, what is in it, and how do you make sure to kind of pen them in so that they're not trying to push the boundaries of that. And then I think, let's all be honest, you're healthcare entities, you're providing care to patients. And so you're also wanting to make sure that you're working with the team to make sure that care is not disruptive, and that the priority of your organization to be able to care for people is not severely interrupted by this kind of government enforcement action.
Ryan, so what kind of instructions do you give your employees regarding search warrants? I mean, in addition to their first call should be to the legal hotline, it's going to take a while for that legal rep to show up there. So what kind of tools or tricks are you giving them to handle an impatient law enforcement officer who's wanting to execute on his search warrant?
Yeah, a lot of it is exactly what Miriam just said. It's first and foremost remain calm and professional. Ask for identification, verify who they are, and ask for their documentation. Look at what they're needing to get at, and then getting that in front of counsel as quickly as possible, so we can assess, is this an administrative subpoena or warrant? Is this a judicial search warrant? And then once it is being executed, assuming all that stuff kind of checks out, then it's really, for our leaders, more than our frontline staff, to be there and to follow the law enforcement official, try to document as much as you can about what is being collected and obtained, and making a log of what they're taking and things like that. I will add, I think Miriam touched on this as well. Maybe the case that law enforcement officer just isn't wanting to wait around for legal to verify what he's after, and is perhaps aggressive, and in those situations our recommendation is we'll deal with the fallout later, but don't be obstructionist. Don't try to intervene and preclude them from executing, because that can have some pretty serious consequences as well.
Yeah, and that's where that instruction to document is so helpful. Like, and if you can, like actually assigning one person, like you're responsible for just writing down, tracking what was said, how was it responded, so if you had that kind of pushy officer who, is just gonna, take care of business, that you're like documenting kind of the dialogue of that there was a request to wait for legal, was not, or if there is an action that exceeds the scope, there's some documentation of that they were alerted to the fact that they were exceeding the scope and why, and then the fact that they continued to take the process. But it's obvious it's not going to help the organization to like get into a bull's match with executing officers. As you said, it's better to kind of just make sure you document it and deal with it in the aftermath and just be the one who's being cooperative.
So in the case study we used at the AHLA conference, a billing supervisor directed agents to files that were not included in the warrant because she knew they were likely responsive to the concerns that were raised in the warrant itself. So Ryan, give us your thoughts on what is the risk of when employees expand the scope of a search warrant?
Yeah, I think whether it's, expanding the scope of a warrant or, volunteering information during an interview as part of a CID or subpoena, it's really, the risk is letting the proverbial camel's nose into the tent, right? Once the camel's in there, who knows what they're going to want to see in addition to what was in the warrant. So I think making sure staff know to, again, not be overly helpful is really important.
Yeah, it's one of the, it's like so against human nature, right? Like our nature is to like, especially in the healthcare world, right? You're there to help people, like, and so just letting staff know, like, we're not asking you to be a jerk. We're not asking you to do this, but at the same time, don't do the government's job for them. They are asking you for specific things. They're asking you these questions. Answer those questions. Give them those documents. You don't have to do anything more than that. I think it's really hard to do in practice, but I think it is always good to just remind people, like, you don't, your good intention might have some significant consequences. So just, try to rein it in for those types of things. Dealing with challenges is what you guys do on a day-to-day basis, right, Kris? So, and kind of thinking about search warrants, I think given the current administration's aggressive stance, shall we say, on immigration, I'm curious about how your organizations are kind of approaching, kind of being prepared for this heightened level of enforcement from the federal government.
So my organization, like Ryan's, we've instituted a program where if immigration enforcement officials show up, like any other legal enforcement official with a search warrant, they're to immediately call legal counsel. Unlike Ryan's organization, I am it. So it's either calling me or calling risk management, and staff have my cell phone number to call me 24/7. But we've also taken a lot of efforts to distinguish what is public space versus what is private space, so that we can kind of restrain where immigration enforcement officials may go. We want to try to keep them out of the patient spaces themselves. We've also educated staff quite a bit on that they have the right to remain silent. They don't have to be answering questions posed by immigration enforcement officials or any legal officials. They can, wait for legal counsel to arrive. But they should not be obstructionists either. And that doesn't mean we have to actively help them. We just can't hinder a search. So, but then staff has also been cautioned not to interfere with what law enforcement chooses to do. So if they want to blow past, don't physically obstruct them from going into areas that we may have told them that they should not be entering. And it's a lot of training staff on what patient rights are, what legal rights are, what information we can disclose, what information we can't disclose. So it's been a lot of training. We do encourage them to document all law enforcement interactions, clearly write down if they're taking things, what they're taking. We do have surveillance cameras in the non-patient areas, so they will be recording, and we would keep those surveillance recordings.
Yeah. Yeah, so, you know, a lot of the same recommendations, but definitely very, very front and center. Unfortunately, right now that so many organizations are kind of struggling with. So, well, you know, I think we've discussed various enforcement tools and things. Is there any kind of last minute kind of takeaways that you wanted to share with the audience?
I'll say, if I, kind of boiling it down, I think you've heard some themes today, but I think, when you receive any kind of notice, from the government, it's important to acknowledge receipt in a timely manner, to really look and understand the scope of it, get it an extension if you need, and really document everything and coordinate with the right team and the right stakeholders.
Kris?
Yeah, another key takeaway is make sure your staff know to get legal involved immediately when any of these actions occur or tools are used. And when warranted, engage outside counsel. They can be your best friends when these situations arise.
Yeah, yeah. And yeah, just kind of talking about these things before they happen. You can't control when you're going to receive an enforcement action, but you can control how prepared you are to respond. I want to thank both of you again for your time, for your expertise on these topics, on like working with me on putting together that presentation, and Kris at the very last minute being willing to jump in when we had a last minute panelist who couldn't come. Absolutely, I'm fully in gratitude to you for that. Being a co-presenter with both of you was a highlight for me this year at the In-House program, which was fantastic. And so we want to use this opportunity to remind the audience that next year's In-House program and the AHLA annual update is going to be in New York City. So excellent conference, exceptional city. I think it's going to be epic. So hopefully everyone will be able to take advantage of it. And again, thank you both.
Thank you, Miriam. It was a pleasure.
Thank you. Thank you.